Not enough people are talking about this part of the oral arguments last week when Sotomayor essentially dog-walked and forced John Sauer, the United States Solicitor General, handpicked by Donald Trump because he's the one who also argued Donald Trump's obstruction of justice case, and backed him into a corner. It's brilliant. So I'm going to play the full clip, but I want to give you the context of what I'm talking about and then also help you understand a little bit further. So what the Trump administration is doing, they know very well that if you were born in the United States, the language of the U.S. Constitution says anyone born on this soil gets citizenship. The United States Supreme Court, it was that determination of whether or not that's true, and still in effect, was brought up to the United States Supreme Court on 4 different occasions. And Sotomayor pointed out on 4 different occasions that we affirmed what the Constitution says. Additionally, Congress, in the Immigration and Nationality Act, enshrined in a law, an act, that once you are born on U.S. soil, you're entitled to a U.S. citizenship birth certificate. 3 sites. That's unequivocal. The Donald Trump administration know that. So they would definitely not want the Supreme Court to decide that on appeal. Instead, what they're going to do is say, you know what we want to do instead? We want to deny it to babies. And in order for a baby to get their citizenship, that baby has to sue us first. And then a district court judge says to that baby, what, you're entitled to your birth certificate. Then we say, okay, and we give that baby and that baby alone. And then we continue to deny other babies all across America born every single day, thousands. We deny all of them. And then if any of them are not given a citizenship, they have to come and sue us. That's when they say we don't want a nationwide injunction. They don't want a judge to say, you can't do that. That's unlawful, not just for this baby, but for all babies. That's what they're challenging. During the oral arguments, this is when you might have seen Amy Coney Barrett kind of step in and kind of like ask, did I stutter? Did I hear you tell Elena Kagan that even if the Second Circuit Court of Appeals, for example, tell you that you can't do it, that you won't even listen to them? Not only are you not listening to the district court judges, you're not even listening to the circuit court judges. If they say that, is that what you heard? Justice Ketanji Brown Jackson said, so you're essentially, let me understand, because I don't understand, you're essentially coming to us saying that if one of our lower court, district court judges tell you that what you're doing is unlawful against the Constitution, you want to continue to be doing that thing to other people? And if they don't have money and can't afford to come up here, they just got to suffer. Is that really what you're asking us? That's what she's saying. I'm just giving you a layman's term.
The concern, I think, is that your argument seems to turn our justice system, in my view at least, into a catch-me-if-you-can kind of regime from the standpoint of the executive, where everybody has to have a lawyer and file a lawsuit in order for the government to stop violating people's rights. Justice Kagan says, let's assume for the purpose of this that you're wrong about the merits, that the government is not allowed to do this under the Constitution, and yet it seems to me that your argument says we get to keep on doing it until everyone who is potentially harmed by it figures out how to file a lawsuit, hire a lawyer, etc. And I don't understand how that is remotely consistent with the rule of law. You know, a system, and I appreciate that you go back to English common law and the Chancery Court, but they had a different system. The fact that courts back in English Chancery couldn't enjoin the king, I think is not analogous or indicative of what courts can do in our system, where the king, quote unquote, the executive, is supposed to be bound by the law. And the court has the power to say what the law is. And so one would think that the court could say, this conduct is unlawful and you have to stop doing it.
So at some point later on, Justice Sotomayor said, okay, so I hear you now. I see what you said about the Second Circuit. I see what you're saying about the nationwide injunction, that we're not entitled to do that. All right, fine. How about this? Let me give you one. How about we do this thing called certiorari before judgment? I mean, like, we don't have to wait till final judgment. We just going to, because of the equities, because of what you're asking is so crazy, before we would just grant cert right now, and we have a briefing, and we just determine whether or not, because we know you don't want that before for us. You don't want that. So we just cert before judge. We use that tool, cert before judgment. How about that? He was like, well, nobody asked for that. Later on, when it was time for the lawyer that's representing the trade associations to argue, Sotomayor essentially walked her into that. She says, you want to ask that? It hasn't been asked. No one briefed it. No one asked about it in the briefing session. The way it works is like your brief, like you turning your briefs, your original brief, your reply briefs, and whatever, all those briefs happens, and then you have the oral arguments. So on the briefing level, no one asked for certiorari before final judgment. No one asked. So she set it up she set that lawyer up and say, do you want to ask for that? So the lawyer was like, yeah, I want to ask for that. Sure. So now it's on the record. Now that's an option. So then she says to John Sauer, how about we do that? How about that be a tool for equity? You think that's okay? Could we do that? What do you think about that? Is that an option for us? So smart. So he was like, yeah, I guess that could be an option. And also, by the way, they had also said they weren't for class actions. They didn't think class actions could work. So in which case, during the course of the oral arguments, they conceded. They say, yeah, we're okay with a class. And here's the thing, as I said before, if you follow my account, I've said they've already proven themselves they can't be trusted, because when the Supreme Court decided on the Alien Enemies Act to not just outwardly say Donald Trump's March 14th executive order trying to use the Alien Enemies Act as a way to deny due process to all these folks, instead of just blanketly saying that's unlawful, executive order is unlawful, they just said everyone's entitled, so you have to give everybody due process rights. And so because they said that, there have been classes created all over. And each time there's a class created, you know what happens? The Trump administration tries to declassify it. They've done that in New York. They did it in California. They're doing it in Texas. They're trying to ask the judges to remove the class. So here you have John Sauer last Wednesday saying they're okay with classes, but the Supreme Court can see you guys going to all these different jurisdictions asking the judges to declassify. They just asked the New York Judge Alvin Allerstein, can you remove the class? And Judge Allerstein says no, because these people they don't speak English. They don't have lawyers. What you're trying to do is to deny them of the due process rights that they're entitled to under the United States Constitution. And you're saying to remove the class, so you can remove the class so it only applies to the people who sued. So all the other people in our jurisdictions who are entitled to due process, you can deny them the due process. That's why you ask us to remove the class? No! He said no. So you see how the contradiction, you're saying, no, we're cool with classes, but you're trying to do, so essentially what you want to do is deny people. So what Sotomayor did, and then she said this a couple of times, I'll play the clip after this. She said, okay, so imagine a president, perhaps a Democratic president, she didn't say that, says, I think that Second Amendment, the guns are a problem in America, so I'm going to take everyone's guns. So clear violation of the Constitution, Second Amendment, just the same way birthright-citizenship is enshrined in the Constitution. Your Second Amendment right to have a gun is in the Constitution. So she says a president could just say, we're not going to abide by that. And in order for you to get your gun back, you have to sue us. And when you sue us, it's only you get your gun back. Everyone else, we still get to keep their guns. Every single person has to sue to get their guns back. That's essentially the precedent you're trying to set up. That's what you're asking us. It's the short-sightedness stuff. You want us to give Donald Trump this right to just violate the Trump. And you know, you're asking this while the courts aren't dumb. They see what the hell is going on. They see what Trump is. Forget freaking psycho Alito. And imagine a Democratic president decides, you know what? Neo-Nazis are a problem. They are criminals and crazy. So what we're going to do is we're going to take, the homegrowns are a problem too, because they're domestic terrorists. So we've made an arrangement with the people of Papua New Guinea. The New Zealand government said they will take all of our neo-Nazis and just take them for us and imprison them. We're not going to give them, we just want to remove them from the country. They're homegrown. And if you have a tattoo that looks like any of these tattoos that neo-Nazis normally wears, then we're sending you off. Imagine, these tattoos of neo-Nazis are all white. So if you are white and you have any tattoo a tattoo that resembles anything, I'm going to show you Pete Hegseth's tattoo right here too. If you have any tattoo that looks like any of these neo-Nazi tattoos, then we can just send you to New Zealand, deny you the right to habeas corpus. We don't give you the right to say that tattoo is related to my child. It looks like it. That's good enough for us. And that's what Donald Trump has done to these Venezuelans. He's saying that your tattoo is just like all these gang tattoos, and so for that, you don't get the right to say that's that's not me. That has nothing to do with me. That's Autism Speaks tattoo. That's a tattoo related to my son. That's not. There's kids. There's a lot of the people that they sent to CCOT have tattoos that are not gang related, but the Trump administration decided that's gang related. We send you off, and that's what y'all are defending MAGA, and that's what Alito and Thomas, I guess, wants to continue that kind of crazy cycle. So if you don't want a Democratic president, because Donald Trump's a 78, he ain't gonna be president forever, to come in and use the same tools that Donald Trump does to jack up y'all in your Second Amendment, I think y'all want to think twice. That's something to think about. JJ Legal, share this video with other people. Anyway, on the other side, listen now to Sonia Somona's dog walking. Yeah.
I think correctly that if Article 3 precludes universal injunctions, then even class actions are illegal. That's what you're arguing, isn't it?
I disagree with that profoundly.
How could it, if Article 3 and only prohibits injunctions that affect non-members or non-plaintiffs, how could Congress give a remedy like a class action?
In an article or in a Rule 23 class, every represented member of the class has standing by hypothesis. So every single one of them has an Article 3 injury, and Rule 23 again.
So that would be the only method.
It would be very similar to the Bill of Peace, where all those parties, even though present in a representative capacity, are bound.
We can act quickly. If we are worried about those thousands of children who are going to be born without citizenship papers that could render them stateless in some places because some of their parents' homes don't recognize children of their nationals unless those children are born in their countries. They're not going to be receiving federal benefits because that's the claim of the plaintiffs here, that of the state plaintiffs, that they're not going to be able to provide services to those children. Shouldn't we grant cert before judgment on that issue? If we're afraid that this is, or even have a thought that this is unlawful executive action, that it is Congress who decides citizenship, not the executive, if we believe, some of us were to believe that, why should we permit those countless others to be subject to what we think is an unlawful executive action? As unlawful as an executive taking the guns away from every citizen.
Cert before judgment would be another tool, but through which this court could act expeditiously.
This is the kind of case where the equities would call for that. And why wouldn't it? It's a pure legal question. What does the Constitution mean with respect to citizenship? There are no individual facts that would alter our conclusion. If we can't do it by a universal injunction, because you say Article 3 doesn't permit that, Article 3 wouldn't permit us to give a universal injunction, even if we rule. Why don't we grant cert before judgment, so that all of these parents would have a firm Supreme Court decision that they can take where? Because you're saying nobody can grant a universal injunction.
No party has asked for that in this case, and I think one reason is that would deny the court of the benefit of percolation in multiple lower courts of a novel and sensitive and important constitutional question.
We have novel courts who've percolated this issue and said you're violating precedent. Not only precedent, but the plain meaning of the 14th of the Constitution.
Respectfully, I think what we have are lower courts making snap judgments on the merits that ignore the fundamental principle of the 14th Amendment, that it was about giving citizenship to the children of slaves, not to the children of illegal immigrants who really were not even a very discreet class at that time. And that's the sort of argument that deserves percolation.
There were some people in Congress who argued against the 13th Amendment just because of that. Some people who argued against passing the amendment just because of that, because it would give citizenship to gypsies.
I think the relevant history of the 14th Amendment is the statements of Senator Trumbull, who emphasized that domicile was the key criteria. And he said that in a letter to Andrew Jackson. We've cited in our Ninth Circuit briefing a host of decisions that back that up.
Rejected repeatedly. We can go into the history of citizenship, but I still go back to my question. You claim that there is absolutely no constitutional way to stop, put this aside, to stop a president from an unconstitutional act, a clearly, indisputably unconstitutional act, taking every gun from every citizen. We couldn't stop that.
I disagree with that for the reasons I've said, including the equitable tools.
No, because you said to us we'd have to wait until there was a final judgment. You're not sure you would respect the judgment of every circuit. You're not sure that you would respect even a final judgment of the Supreme Court, because it only binds the parties before it. And if there's no class action, that only binds the parties before the court.
I don't think there's a, so to speak, really, really unconstitutional exception to the strictures of Article III or the scope of equitable authority, and the court should not recognize one, because what we see, not just in this case, but in the 39 others, is that the district courts who are issuing these injunctions all passionately disagree with the thing that's being challenged in that. So that principle that, well, this we think is really unconstitutional, therefore we should ignore the general principles of Article III, is not a principle the court ought to adopt.
Justice Kagan.
Brilliant. Share this video. Each one teach one. JJ Legal. Follow for more.